Hello everyone, welcome to Special Needs Planning with Special Needs Hawaii. In this video, we will be discussing the concept of guardianship and important things to know about it. Guardianship is a topic that our clients are always asking about, so we are really excited to make a video about this. Before we get started, we want to remind everyone that this video is for educational purposes only and is not meant to serve as a substitute for in-person counseling with a professional. For more information, talk to a special needs planner or attorney who can provide you with more information and help you to create a plan that fits your specific needs and goals. With that said, let us get started with the video. In most states, when someone turns 18, they are considered an adult and are expected to make all the right decisions about finances, medical decisions, and life. However, this may present a dilemma for some caregivers of dependents with special needs. For some dependents, making day-to-day decisions can be challenging. Essentially, there are two types of decisions that can be made: personal and financial. Some dependents may be able to make both, one or the other, or none at all. When this happens and help is needed, you may want to consider guardianship. What is guardianship? Guardianship is a legal process during which a court is asked to find that a person is unable to make important decisions or manage their own affairs on a daily basis. In most states, a guardian is responsible for personal decisions, ranging from day-to-day decisions to medical decisions, housing, food, etc. On the other hand, a conservator in most states is responsible for decisions regarding a person's finances, such as property, income, and financial matters. Most special needs providers and advocates would recommend the least restrictive form of guardianship or conservatorship, as independence, dignity, and integrity are in the person's best interest. If a person has capacity, it is important to involve them in the decision-making process. Guardian responsibilities. Generally, these will only be to provide for the need of the dependent. Sometimes, a guardian will have to ask for special permission to do things, such as for the sale of a piece of property or to change living circumstances. The guardian must file a report, usually annually, to verify that the dependent's needs are met. If finances are involved, records must be kept and reconciled. If the guardian fails to satisfy the court, they may be removed or subject to civil penalties, or both. Who should be the guardian? Instead of appointing people as guardians or conservators, consider appointing institutions. For the guardian, consider appointing a professional trustee. On the other hand, an institution, such as a bank, might be better as a conservator to handle the financial decisions. Whether or not you have people or institutions appointed, both the guardian and conservator are accountable to the court. Institutions are great to use because they understand the full scope of their responsibilities, have the expertise to do their job, and have longevity. So how can I name a guardian? If the caregiver and their dependent feel guardianship is right for their circumstance, and the dependent is over 18, then the caregiver must file for guardianship in family court. But if the dependent is under 18, the caregiver can name a guardian and conservator in the will. If a guardian is named in a will, the state has final approval, but will give the choice in the will highest priority. If a guardian is not in the will, the court will make the decision, and it may not be the person you would have chosen. It must be proven to the judge the need for guardianship, lack of capacity to make certain decisions, that the proposed guardian is fit to serve, and that there are no less restrictive alternatives available. Witnesses may also be called. The judge will determine that the dependent with special needs does or does not have capacity to make decisions. So what happens if I don't appoint a guardian? If you don't appoint a guardian for your child, then the court will appoint one for you. This is called guardian ad litem. These guardians usually charge high fees, and they may not work in your child's best interest since they won't know anything about the child. As a reminder, guardianship laws vary from state to state. It is always best to consult with a legal professional experienced in your state about guardianship. Thanks for watching. We have more information on special needs planning topics and general financial planning topics on our website at specialneedshawaii.com. Make sure to subscribe for future content on financial planning and special needs planning educational videos. We will see you in the next video.